Welcome to Guardians of Innovation, Patent and Trademark Law.
Hello and welcome to Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. I am your host, Kevin Rosenquist, and today we're going to talk about the evolving relationship between inventors and IP attorneys. Vincent, great to see you again.
Hey, good morning. How are you today?
I'm doing great. Ready to chat some IP attorney and inventor relationships. So tell me what the typical challenges are for entrepreneurs regarding protecting intellectual property.
So, there's limited knowledge, right? They're not sure what it is that they have. So, the first thing is just figuring out, do I have a patent, a trademark, a copyright? And we talked about the differences in those in the past. And the next is resources, right? I mean, they don't have a lot of money. So there's different strategies for entrepreneurs starting out, and they have to decide and determine exactly where to spend those resources. Does it make sense to file 10 patents on something or one, overreaching trademark that they're going to use originally? Identifying what the strategies of protecting the IP at minimal cost for entrepreneurs is a problem. But even big corporations that have the money to do it, they still have to identify which inventions, which intellectual property they want to protect versus which is, what's the return on their investment for that particular product. And I have meetings with, we call it IP meetings with the vice president of a company and the research and development team and then the marketer. And the vice president always looks over to the research and development. Can we make these? How does it work? Now he looks over to the marketer. Is somebody willing to buy these right now? And the marketer says, yeah, Joe down in Pennsylvania, the distributor said he would love to take a look at some of these. And then they still have to make a determination as to whether or not it all makes sense, how much the patent is going to cost, how much the search is going to cost. So, the limited resources, whether you're a $50 million company or you're a new entrepreneur coming out of the box, you have to determine how much you want to spend. And it always comes down to return on investment. I always say, look, if it costs you $10,000 to get a patent and you never sell a product, then you might as well just throw your money out the window. If you're going to make $1 million off of it, spending $10,000 doesn't seem like a hell of a lot of money. It's nothing in the long run. But at the end of the day, you're still going to have to, make that decision on how to, spend your resources. So then the next thing that I have here in my notes is, the market changes. One of the problems that happens is, and even the product changes, we'll file a patent and it might take a year and a half to get it. And by the time you get it, everyone, when COVID came out, everyone called me up. I got the new mask, right? This is the new mask, right? 2 years later, by the time we got the patent, nobody's wearing masks anymore. It's over, And then, enforcement. Even if you own the patent, at the end of the day, it's costing you tens of thousands of dollars to hire a patent attorney and a litigator to sue it. So how are you going to enforce it? You send out your cease and desist letters and you try to negotiate. You have that poker face that I'm going to sue you if this doesn't get settled. And then that's what happens with most of these patent cases, even if they're hundreds of thousands of dollars worth of damages. They find a middle ground and it becomes a settlement. So limited knowledge, complexity in understanding the process, the market change, and the complexity of enforcement. Those are the main challenges that I see that inventors have.
What should entrepreneurs or inventors look for when they're choosing an IP attorney?
Yeah, so one of the things, certainly you want somebody competent. If you have an electrical or a software or a mechanical, maybe the patent attorney that you want is really specialized in that area. I work with a lot of independent inventors, and it's not really high complex inventions. Most of them are mechanical. I have, written patents for apps as well, software patents, and I have written chemicals. I have a chemical background I have a couple of corporate clients that have chemical patents. And so I've kind of been able to spread it out, throughout all different, I don't specialize in any one, but mostly I do mechanical stuff. But if you have something that's extremely complex, you might want to have somebody that specializes in that particular area. Certainly the experience of the attorney. I've been doing this for 25 years now. Has certain value to it. A lot of times you'll go to a big firm, and although you talk to the partner, then they assign it to the new associate that just got out of law school last week, and you're not getting quality work there. One of the things that I do to compete with the big firms is to offer a flat fee. So I kind of know what a patent costs, and the time that it takes me to write it, and the cost for the government fee and the drawings are pretty much the same. The government fee is always the same. The drawings are a little different depending on the complexity of how many drawings you need, but you could get a roundabout figure. What it's going to be. So I kind of look at it and say, look, this is how much it should take and how long it should take. This is what I'm going to bill you. It's a flat fee. You know what your cost is going up front. So those are a couple of things that you might want to discuss with an attorney.
Definitely. How do you help entrepreneurs during the early stages of business development?
So like we spoke about before, is identify what you have. Do you really have it? Right? Is it an actual invention that's worth patenting? We do our search. The same thing with the trademark. There's somebody already using your trademark. And with trademarks, it's a little different because the rule isn't that it's identically the same. The rule is that it's confusingly similar. So you could have Domino's pizza and Domino's sugar, but nobody's confused when they go to buy sugar in the sugar aisle. But if Domino's Pizza wants to start selling salt in the sugar aisle, well, that's going to be confusing. So identifying what type of thing that you have. Obviously, the patent attorney will draft the patent application, draft the trademark application, file the copyright. As far as doing it right the first time, I always say, when people come to me after they try to do it themselves, especially for trademark, both trademark and patent, if you came to me and you were building your own house and you said, could you fix it? I got the roof in the basement. I'm like, there's no way to fix this. We got to start over from scratch, right? Mm-hmm. You could lose your rights because you just filed it wrong. So in trademark, might be you might get away with it and get it to go through, but if you do it wrong, you'd have to start away from scratch, and you might lose it altogether. As far as audits, you could get, if you have a series of patents and trademarks, they call it your intellectual portfolio, and we can audit it and determine what it is and what we need to protect and to control it. And the last thing I have here is educate. Educate either your employees or you on what it is that you have. And a lot of times employers, like in research and development, the employees, they'll invent something and they won't even realize that they invented it. They'll think, oh, this is no big deal. So what we try to do with those type of clients is we have, anytime they come up with something new, whether they think it's patentable or not, we have a disclosure form that we created that they fill out. And then we have a review like at the end of the month or every other month, and we go through all those new ideas and say, are any of these worth patenting? Are they even patentable? Where a lot of times they might have invented something, they put it on it, and then they lose their intellectual property because they didn't even know it. So what we try to do is go in there and we teach like a course in patent law and in fact, I co-wrote a book called Patent Law for Engineers, right? Fundamentals of Patent Law for Engineers. And we try to educate you and educate the individual to be aware that what they're creating has, great value if it is intellectual property.
Well, that's awesome that you do that much in education. So flipping that around, how should entrepreneurs effectively communicate their needs and their concerns with you so that you can help them in the most efficient way possible?
So to this question, I wrote down 3 points. Be specific, provide context, and ask questions. One of the things is that it's a matter of communication, right? So a lot of times an inventor knows the invention so well that they just take for granted that everybody else fills in the blanks. And I always say, look, make pretend you're explaining it to a 10-year-old so you don't leave any of the nuances out. Because if you don't tell us, we don't really know it. And so you got to be very specific of what it is and not leave anything out. You have to be totally transparent. You can't hold anything back from the patent attorney. You have to make sure that he's aware of anything that's material to patentability. And then, and finally, you got to definitely work together and in being able to go back and forth. And sometimes, it's difficult to find the time to do that. And a lot of, especially like, inventors that are by themselves are fine. They really want you to know it and they want to learn it. The president of the company is always too busy to do anything, right?
Yeah.
And he doesn't want to communicate. You're like, look, this is what I'm paying you to do. But if you don't tell me what it is, how am I supposed to know what it is?
Yeah. So you're not an expert on their company. Yeah. Yeah, that makes sense. How can an IP attorney help mitigate some of the risks associated with IP infringement?
So, first you conduct the search, right? So we search to see what's out there. And there's different types of searches. There's freedom to operate search. So I don't want to get a patent on it, but I don't want to get sued either. So I got to know what's out there and what people have. So we want to do a freedom to operate. There's patentability search. Maybe I do want to get a patent and I want to stop people from doing this, but I don't want to spend all this money on a patent if it's already out there because I'm just going to be rejected anyway. So, and then there's, infringement. Am I actually infringing on this product? Here's the patent. Could you take a look at it for me and say, if I produce this product this way, will I infringe on this patent? Very specific. So conducting searches is the first thing. The other thing that we could communicate with is the context and how you want to use it and where you want to sell it and how do we want to protect it? Those are type of things. And then again, I think asking as many questions as you can. And I always use the joke. My wife says I'm a data dump. I don't show up. I keep talking and talking and talking. But the more questions you ask, the better educated you will, the better you'll be able to understand it. And I always say, hey, look, especially when you're going to hire somebody, say you were a general contractor building a house, you would get 3 bids from the painter, the electrician, the hardwood floor guy, and I'm just the plumber, right? So get 3 bids from the plumber, ask as many questions as you can, learn as much as you can about the process, and then you can get a better gut feeling of who you're working with. Mm-hmm. I said when I was looking for a diamond ring for my wife when I was 28 years old, I had no idea what a diamond ring was. How do you value it? And then, the first guy didn't really tell me much, but he did tell me that there's 4 ways you judge a diamond, the 4 C's: the color, the cut, the clarity, and the carat. And the next guy I talked to on the phone, or I went to see, I said, oh, what's the color? What's the clarity? Is it an A? Is it a B? Is it a C? Is it what? Next thing you know, he thought I knew what I was talking, and he's spilling his guts. He's here, put this loop in your eye. You see in the right quadrant, there's this, occlusion of the thing. I couldn't see anything.
Right.
He was telling me it was there because he thought I knew what I was talking about. So ask questions and learn as much as you can. I think that's definitely something that you need to do.
Did you say your wife calls you a data dump?
A data dump, yeah. I just keep talking. You just don't ask me a question. Yeah.
I have a feeling my wife would say the same about me if she knew that term. I'm not going to tell her.
Don't tell her.
So obviously, we've talked about this. A lot of people are going to go and try to do this themselves. There's online tools. You can go right to the website and search and do all that stuff on your own. But how are you able to assist entrepreneurs in developing a comprehensive IP strategy that they might not have in mind when they're thinking about just going and doing it themselves?
There's a whole courses of strategy and filing, parent, child patents. We start off real wide and then we narrow it down. And sometimes when I do searches, I find like 2 or 3 patents that look almost identical. I'm like, what are the differences between these? But that's the big corporate strategy. So we can help map out those type of strategies, how to file it, what parts of it we should file. Should we file separately? And certainly, as far as getting it right, not leaving anything out. It's the biggest thing I see when people try to file themselves is as much as it's just a big scrambled egg and you can't make heads or tails of it, it's just missing everything. They think that they're filing it right. And even guys that have, worked as an engineer and had many patents to their name, they've never written it, and then they decide they want to write it. And it becomes this long, drawn out, application that kind of goes off on tangents that's not putting relevant information in there to the patent. And so just the strategy and how and what to put in there. And I remember the first time I wrote my first patent, in the first couple of years of writing it, I didn't feel comfortable. I had an old guy, his name was Arthur Cookfair, God rest his soul. He'd probably be 100 by now if he was still alive. But I remember going to him, and he was my mentor. And even after a year or two, I was still going to him and help him, letting him look over my work. And there was one point where he said, I don't think you need to be here anymore. But even then I still didn't feel comfortable, and so I don't see how, even if you're the smartest guy in the world, just to write it, it's like doing your own operation if you're sick instead of going to a doctor. I'm going to sew myself up. So maybe you can do it, but as far as strategy and deciding how to file it and what to write it, you really need to have somebody that does it, for a living to do it for you.
Yeah. Yeah, make sure you don't miss anything for sure. How important is ongoing legal support as the entrepreneur's business grows? Because I think a lot of people probably think, oh, I'll get an attorney who helps me on the front end, whatever. But there's more to it than that, right? There's an ongoing relationship there.
Well, yeah, and for one thing, you have to maintain your patents. So we docket it and we keep track of it, but it's constantly, you'll get a phone call. I saw this. Is this a problem? Is it a problem for me? Is it a problem for them? Should we sue them? I mean, once you file it, you're filing it for a reason, to stop others from being able to use it, right? And I always say for the trademark, it's a sword and a shield, right? The sword is if you use my trademark, I'm going to cut you off below the knees with the sword. I'm going to stop you from doing it. If you decide you want to stop me from using my own trademark, I have the shield to stop them from attacking it. So it's always ongoing. And like you said, the complexity of the patents and the timing of it, things change. You might have to update it. You might have to change things. Maybe we see something afterwards, into the infringement in the first 2 years, and we do a reissue patent, or we file the new and improved model. And because you have to, so it's always an ongoing relationship. And then there's, licensing agreements that you have. Certainly if you're going to make a deal, you want to have it, written down. So what do they say? An oral contract is not worth the paper that it's written on. So you want to make sure that if you're going to have an agreement, all the factors and all the strategies are in writing. So we're not trying to fix it later. I got a call yesterday from a client that's going to be a member of an LLC for a clothing company, and he's going to run it. And and we've got all the trademarks already, but still, he's like, okay, can you help me look at this contract that they want me to sign to do it? So it's always an ongoing, evolving relationship with the patent attorney and the client.
Makes sense. All right. Well, thank you for joining us on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. If you'd like to get in touch with Vincent, please visit lotempiolaw.com and be sure to like and subscribe to the channel here. Vincent, so good to talk with you and look forward to the next one.
Thank you. It's always talking to you. Always great talking to you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.